Good morning. This is Judge Paul Gaudet on the 10 o'clock calendar. I'm calling Crozier versus Crozier, case number D-22-646896. Do I have the plaintiff Jennifer Crozier available?
Yes, Your Honor.
Would you please turn your video on?
I'm trying to get it connected.
Do I have the defendant Garrett Crozier available?
Yes, Your Honor.
Good morning. Okay. I guess the reality of the situation is we have an evidentiary hearing on May 16th, 2023, and I guess the little discussion I had with the two of you regarding what I perceive to be both of your inadequacies as parents had no bearing on you whatsoever, because I have additional motions being filed for, I'm going to be honest, trivial things that are just amazing to me. But what I'm going to do is I'm going to allow, let's see, the defendant filed the first motion. Sir, succinctly go ahead and tell me what it is you want to do. You want me to do.
I wanted to switch the vacation times, the summer visit or the vacation visits, so that when Mia was with me during those holidays, it would coincide with when her step siblings would be here. The mom would not agree or discuss that any further, so I filed a motion to bring it before you. Just in the interest that she doesn't spend holidays as the only child. I also requested that.
You also requested $29 and $49. Come on, what are we doing? First off, what basis do you have to even suggest that I can hold this woman responsible for your obtaining copies of school records?
The email records that I submitted that she refused to give me those
What
records.
what order is there that I'm sorry, I don't mean to lose patience with you. You see, this is what's going on. You feel empowered against the mother, and the mother feels empowered against you. So the two of you doing this in proper person, that means you incur no cost, no fees associated with doing this, are utilizing the court system to take out your beefs with one another. And ultimately, as I tried to tell you last time you were here, that is going to affect three people. It ain't going to affect me, it ain't going to affect you, and it ain't going to affect your ex-wife. Who is it going to affect?
The children, sir.
Ah, ding, 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 ding. Miss Crozier, tell me what it is you want to do and why it is you want me to do it.
Yes, Your Honor. I'm sorry, my camera for some reason is
okay,
not
it's okay. We're beyond that point now. I'm trusting that it's you talking to me. Talk to me.
It is, sir. I apologize. I am nervous. I'm requesting that Mia be returned back to me due to the fact that the father has child abuse charges, and I have placed in there the child abuse charges and other evidence of doctor's notes and everything. I do want to make clear that I did not say no to the holiday switch. I actually said that's fine. I asked if Mr. Crozier would mind if I took a little extra time from the summer for her sister's graduation, and that's where it went downhill.
I read the text messages or the emails. The two of you act like children. Okay, this is going to be the order of the court, okay? The court that finds that it has jurisdiction over the parties and their minor children. The court finds that the matter recently proceeded to an evidentiary hearing on May 16, 2023, with the court announcing its decision to modify custody of the party's younger child. There was a delay in submission of the order from that hearing, which was finally entered on July 3rd, 2023, in the form of a custody decree, which was submitted by the defendant. The court finds that now before the court are such petty things as requests for reimbursement of small sums of money, allegations of lack or failure of communication, and disagreement on days for custodial or visitation exchanges. The court finds that the communication between these parents is horrible, with each parent appearing determined to attempt to destroy the other parent's relationship with the minor children. That's all sad, guys. Really, really sad. Based upon the foregoing findings and other good cause appearing, I am ordering that both parties will be awarded legal custody of the minor children. I am ordering that plaintiff, Jennifer Dean Crozier, is awarded physical custody of the party's two older minor children, Morgan, who's 15, and Madison, who's 18. Any contact between those children and defendant shall be subject to the discretion of those children, as I previously said. I am ordering that defendant, Mr. Crozier, is hereby awarded physical custody of the party's youngest minor child, Maya or Mia, who's 8. Plaintiff shall receive visitation, that being the mother, shall receive visitation of the minor child each summer. Now, unfortunately, the two of you can't even agree on days to exchange the child. So now Judge Gaudet is going to impose days upon you, okay? This is how silly this is. I don't want to hear anything about I'm not available. These are going to be the days of the exchange, okay? Exchanges of the child, plaintiff shall receive visitation with the minor child each summer from the first Saturday in June until the last Saturday in July. Exchanges of the child shall occur in Flaming George, Utah, unless specifically agreed otherwise by the parties in writing. Text and email shall suffice for such a writing. Plaintiff shall also receive visitation with that minor child for the Thanksgiving break from school during odd years and the Easter spring break from school during even-numbered years. Plaintiff shall finally receive visitation with the minor child over the Christmas break commencing December 26th and continuing until the day before school resumes during odd-number years, and from the day which school ends for the Christmas break and continuing until December 26th during even-numbered years. The court finds that based upon the timeshare set forth above, the defendant father is an obligor parent of the Nevada Administrative Code who is responsible for payment of child support to plaintiff for 2 children. And plaintiff is an obligor parent of the Nevada Administrative Code for payment of child support to defendant for 1 child. The court computed the gross monthly income of defendant to be $6,042 a month. The court computed the gross monthly income of plaintiff to be $3,120 a month. Applying the dictate of the Nevada Administrative Code to the gross monthly income of the parties results in plaintiff's support obligation being $500 per month and defendant's support obligation being $1,325 a month. The net of those 2 obligations results in defendant being obligated to plaintiff in the amount of $825 per month commencing June 2023, as I previously said. I am further ordering that child support shall be due and payable by the last day of each month. I find that the parties are actually at odds over medical insurance coverage available for their minor children, as well as responsibility for that coverage. To resolve this ongoing dispute, I am ordering that medical insurance coverage for the minor children shall be provided by both parties for all 3 minor children. Each parent is to establish coverage for the children within 30 days of today, July 25, 23, and promptly provide the other parent with proof of that coverage and card or documentation necessary to utilize the coverage. I guess we're going to be arguing over what constitutes prompt. Prompt, you should provide within 2 weeks of the coverage being available. It is further ordered that the parties shall be equally responsible for any medical or similar costs incurred for their children which are not covered by insurance, such as deductibles and copay. The 30-30 rule shall apply, which will require the parent incurring the costs who seeks reimbursement to provide notification of the costs incurred within 30 days of the cost being incurred, and the other parent reimbursing, within 30 days of receiving notification of the cost incurred. Failure to provide notice of the costs incurred within said 30-day period of time shall constitute waiver of the right to seek reimbursement. It is further ordered that each party shall submit the information required in a variety of Nevada revised statutes. It is further ordered that any other issue raised by the pleadings before the court today is hereby denied. The parties are further admonished that bringing trivial issues before the court in the future will be the basis for the court to make findings pertaining to the parties being vexatious litigants. I would strongly urge both of you to look up vexatious litigants in the state of Nevada so you can see what can happen to you if I make those findings. With those findings of fact, conclusions of law being set on record, the court is actually signing off on the order from today's hearing. If you check your email, both of you will be provided. I wish you both the best of luck. I really feel for your children. Your children are products of their environment, and you guys create an environment that's going to set these children up for failure instead of success. Have a good day. We'll talk to you later.